Heidi, good afternoon. Sounds like it was an explosive day in court. Please excuse the pun. What happened?
Yes, Brendon, I think yesterday as well as today, quite explosive in court. You have the judge that's making it very clear to the defence as well as the National Prosecuting Authority, which is the state that has brought this case forward, that in April this year, this matter will be in the courts for 6 years. And the judge is saying that this is actually unacceptable and there has been delay after delay. The judge making it very clear that they can clearly see that the court's time is being wasted here. There's delaying tactics, which seems to appear that it's coming rather from the defence rather than the state, and that there has been application after application from the defence to either move the courts, question the jurisdiction of the Gauteng High Court over this matter, take an application to the Constitutional Court, then to the Supreme Courts of Appeal. Yesterday there was a further delay because the defence did not want the media granted access, to have any access rather, to have this matter covered on live TV or even just recorded and used later on in the day, not necessarily just live recording. And then today in court, when there was supposed to be a formal media application, the defence said in actual fact it's fine, the media can just record. So it's truly been a delay after delay, really frustrating the courts. The twins have been in jail since 2016. They have not been granted bail, and the judge saying it's just really unacceptable. I want us to listen to some of the exchange between the defence as well as the judge on this matter.
We asked your Lordship to adopt the correct and consistent approach previously, where we were allowed that opportunity to approach the Constitutional Court concerning the court which would have jurisdiction to trial the offence.
Since 4 years back.
My Lord, this is not the Constitutional Court attack, the constitutional attack on Pop Tatara.
Oh, I see.
This is an appeal against your Lordship's dismissal of the review, my Lord.
Let me tell you what. You can approach the Constitutional Court, you can approach the President of the SCA, you can even approach the Africa Court of Human Rights. You can approach any court. It's your right.
As the court pleases, my
It's
Lord.
your right.
My Lord.
But this case, on the 7th of February, it's going ahead.
My Lord,
but you can do whatever you want.
the date of the 7th of February was fixed without considering our availability, my Lord. Without considering...
No, you come and tell me on the 7th of February that you're
My
not
Lord, I'm not available on that
because
day.
last year, 2 terms were set aside for this trial.
My Lord, the issue is previously your Lordship allowed my clients to
Yeah,
exercise their right.
I'm going to get this matter on the 7th of February. It starts.
My Lord,
okay.
Will the court give us a formal response to our letter?
You can bring your application anyway. And I don't, listen to me. This court doesn't have to give you permission or consent to approach the Constitutional Court. You are out of this court as far as that application is concerned, because it was dismissed by the SCA.
My Lord,
I don't get in there.
Well, Heidi, to try and speed up the case, I see that the judge, I hear, has ordered the state to hand over the full docket.
Yes, certainly. So what we do understand is that the judge has ordered the state to hand over the full docket to the defence. And the reason for this, Brendon, and it's important to just provide some context here, it seems as though the defence was under the impression that the state was withholding certain information about key witnesses that the state would be bringing forward when the matter eventually goes on trial. And the state is saying that this is not the case. There are no key witnesses. All the information has been provided to the defence, and the defence is saying that no, they are under the impression that there's key information and witnesses that the state is not providing information on. So the judge is saying in order for this to be concluded and for there to be some kind of speed in moving towards this trial date, which is now officially been set to the 7th of February, the judge ordering that the state provides the full docket to the defence. So this is all information, all files, every single document that's in the possession of the state needs to be provided to the defence. And the judge saying this is probably the first time something like this has ever happened, but they would rather have this where they're in possession of all the documents so that they can avoid the defence coming and saying, well, they didn't have this document and therefore they need to postpone or they need to file a new application. So the judge really not having having it, Brendon, saying that these are delaying tactics and it's just completely unacceptable. I just must highlight before we listen to that exchange between the state, the defence and the judge, that the trial is set down for the 7th of February. This was announced yesterday by the judge, and a reminder again today that no matter what happens, the trial will go ahead on the 7th of Feb. Let's listen to the judge on this.
The state cannot provide what we don't have. We don't have.
No, they say you have it.
No, my lord.
Where's the docket?
The docket is in my office at my...
Is it there now?
It's there.
Can you bring it? Can you bring all of it?
Ask the court, please.
Bring the whole docket and every documentation, please. I'm going to give them to the defense. Everything. All right? Even if you have privilege under Section C, is it?
Indeed, my lord.
Bring it. Just waive that privilege, okay?
Ask the court, please.
So that we get on with this case. Because I can see the game has been played here.
Ask the court, please.
Bring everything the state has, okay? And I'm not
a
adjourning. Bring it, and then we'll give it to counsel and attend.
Okay, that ending that report there by Heidi Giokos.